I think we have to let them in.
I am gonna. Hi everyone.
You can't speak.
I was gonna say you can't speak, but I'm sure you're saying hi back, and we obviously really appreciate that. Welcome to our webinar today. We were just waiting a couple of minutes to see if anybody else joins. But we'll it's 3 minutes past now, so we will get cracking. So thank you for coming on our webinar today around preventing sexual harassment, so a new legal duty. I'm Liz Chiver, and I'm the director of Halliday's HR. This is Lizzie Walsh. She's going to give you a wave. She's our HR business partner. I think quite a few of you will know who we are and recognise our faces now. But we work for Halliday's HR, so we're a HR training and recruitment consultancy based in Stockport. We are recording today's webinar, and we will be sharing this with you afterwards, along with a copy of the slides. You can turn your cameras on if you want. We have disabled your microphones just to make it easier for us as we go through. But there's no pressure from us to have your cameras on. So if you're having your lunch or whatever, then that's absolutely fine. But if you do have any questions, then please put them in the chat function, and we'll come to these at the end. Okay, so let's have a look at what we're going to cover over the next 45 minutes then. So we're going to look at a definition of sexual harassment, what constitutes sexual harassment at work, how to spot the signs, why it's important to prevent sexual harassment in the workplace, the impact of sexual harassment, your legal obligations as an employer, and then finally look at the risk assessments. Okay, so we're probably maybe 30 to 45 minutes going through that today. So in just the last 12 months, there have been a number of famous people and businesses that have been under scrutiny for sexual harassment in the workplace. And some of these cases have resulted in going to court. Some employees have been sacked. So businesses have settled outside of court just to make these kind of allegations go away. And just to give you on the screen there, you can see some kind of 4 most recent cases that we pulled together. So the first one there, Pink News. So the couple who run Pink News, the world's largest LGBT news website, they have been accused by employees of multiple incidents of sexual misconduct. You might be familiar with the Blake Lively, so, the scenario where she's accused her co-star, Justin Baldoni, of sexual harassment and creating a hostile work environment on the set of It Ends With Us, and then trying to ruin her reputation after she expressed her concerns. And then McDonald's, so the UK boss of McDonald's was alerted to 75 allegations of sexual harassment over the last 12 months, and 47 of which have been upheld with disciplinary action, and 29 of which resulted in people being dismissed. So big cases there. Then in Tesco, a woman from Northern Ireland has settled a claim of sexual harassment and victimisation against Tesco for 45 grand. She claimed that she'd been sexually harassed by a colleague, which included physical touching and inappropriate messages. And just to give you some stats as a bit of a background, so the Trade Union Congress ran a sexual harassment survey in 2023, and it had the following results. So 58% of women have experienced sexual harassment at work. 62% of women aged 25 to 34 report sexual harassment. 20% of employees faced harassment in the physical workplace. 13% experienced harassment while socializing with colleagues, and 27% of men reported harassment at work. So what is sexual harassment then? So sexual harassment, as defined by the Equality Act 2010, is when a person engages in unwanted behavior of a sexual nature, whether that be verbal, non-verbal, or physical, that creates an intimidating, hostile, degrading, humiliating, or offensive working environment. So just some examples of what might constitute sexual harassment to give you a bit of an idea about what this might look like. So it's things like sexual gestures. It's potentially, intrusive questions about a person's private or sex life. It might be written words. It might be suggestive looks or staring or leering. It might be coercion. It might be spreading sexual rumors about a person, making promises in return for sexual favors, predatory behavior, standing too close or brushing up against another person, unwelcome touching, hugging, massaging, kissing, all of these kind of things, and a few more on there, which you'll be able to read yourselves. But there's quite a few examples on the screen there, and I think it's really important to remember that it doesn't have to be intentional. It can occur from someone of the same sex or a different sex. I think we kind of sometimes think that it's only kind of the opposite sex, but often that's not the case. And that sexual conduct that was previously welcomed can become unwanted at a later date. So it's everybody's responsibility to spot the signs that someone might be subject to sexual harassment in the workplace. And we've just listed on the screen there some of the things that you might be able to spot, or that you might be able to look out for, that might give some kind of indication that potentially someone is suffering from sexual harassment. So they might be socially withdrawn. So potentially they're avoiding team lunches, meetings, or specific colleagues potentially. It might be absenteeism, so increased absences, or the whole presenteeism, so where they're actually at work, but there is that drop in that productivity. Changes in appearance, so potential, changes in the clothes that they're wearing, or, potentially how their hair, their makeup, that type of thing, potentially to appear less attractive. They might have kind of signals of stress, anxiety, or depression. So, those feelings of being uncomfortable, fearful, anxious in the workplace, maybe seeing those physical signs of, maybe tears, that type of thing, the whole withdrawal. Difficulty concentrating. So potentially they might be kind of struggling to make sense of what they should be doing when at work, and therefore it's distracting them from kind of what they would normally do and should be doing on a day-to-day basis. They might be avoiding certain people or places, so avoiding certain colleagues or certain work areas. Or it might be that they're avoiding, meetings where the host might make sexual comments or sexual jokes, or, it might just be that they stay clear of speaking to certain people, or even when they're in the presence of those particular people, potentially they start being, acting more introvert when they start to speak, and, you can feel that kind of shift in their behavior. And that final one's that appearing visually uncomfortable around people. So noticing when those when they do feel any of these other kind of signals, if you like, around particular people, and just there's a vibe, isn't there, sometimes, that you get a feeling that something's not quite right there. So banter here. So light-hearted kind of conversations are an important part of any workplace, aren't they? I mean, nobody wants to go into work in miserable silence and not being able to have a bit of a laugh and a joke with your work colleagues. However, we thought, it was just really important to raise the whole kind of issue of banter, and I think why it's becoming, why we're seeing it kind of become more risky. And I just want to share a case that's recently been to an employment tribunal, where they did highlight banter and the fact that it's not necessarily an excuse. And I might add that this is not one of our clients, the case that I'm going to talk you through. So this was a case where Miss MB, against a solicitors, so a legal secretary, she successfully won her her sexual harassment case against a law firm where the owner was humorously labelled a sexual predator by a colleague. So she was awarded £14,000. An employment tribunal dismissed the claim that some incidents Miss MB reported at the firm were merely office banter. So flippant or light-hearted comments can constitute harassment just as much as those made aggressively, said the tribunal. The tribunal was also highly critical of the comments made about Miss MB in the evidence given by staff. So the ruling highlighted how one witness launched a personal attack on Miss MB with comments about her shocking state of attire on social media, accusing her of flaunting herself and dressing for the office as if she were going to a night out, and then offensively comparing her to a Love Island reject. So all of those things, they're obviously not appropriate and led to her winning her case. Okay, so let's just get down to, I guess, the legal side of things, and I guess ultimately why you're here, and to look at, at what has changed. So obviously sexual harassment at work has always been unlawful. However, on the 26th of October last year, changes were introduced to state that employers are now under a mandatory duty to prevent sexual harassment. So this new duty is to take reasonable steps to prevent sexual harassment of employees in the course of their employment. So the new duty, it only applies to sexual harassment. So it doesn't apply to harassment based on any of the other protected characteristics, so such as race or age or sexual orientation or belief. And it also does not apply to harassment which is related to sex, but is not conduct of a sexual nature. So, the new duty extends to sexual harassment occurring kind of what we call in the course of employment. So this covers sexual harassment occurring within the workplace, but it also covers sexual harassment occurring at work-related events. So things like conferences, at leaving drinks, at other works dues. And the duty, therefore, requires employers to anticipate these particular situations, like when workers might be exposed to sexual harassment, and to take action in advance to prevent it from happening. So this is the change, and this is what is called that preventative duty. Okay, so let's just take a look at what that preventative duty looks like, and what it requires. So it requires that proactive action. So employers must take action before incidents of sexual harassment occur. It must take reasonable steps. So employers must take steps that are reasonable for their size, their sector, and resources. So a bit like the whole reasonable adjustment side of things, when we're looking at making adaptations under the Equality Act, this is the same kind of thing, in that what is reasonable will be different from one company to another. To have a risk assessment, so this is about employees identifying and mitigating risks of sexual harassment, and then putting that action plan in place. So, developing a plan to address those risks that they found, and then to kind of monitor their effectiveness, and what steps they're taking to do that. Okay, now I'm just going to hand over to Lizzie, who's going to talk you through in a bit more detail about kind of, what action you can take.
Thanks, Liz. Yeah, so in terms of what businesses need to do, the law doesn't actually stipulate exactly what steps an employer needs to take to prevent sexual harassment, because like Liz mentioned, what's reasonable for one employer might not be the same for another. But some of the things that you could do are to develop an effective anti-harassment policy, to of course engage your team members and employees, to identify those circumstances or situations that are at higher risk of harassment and put those plans in place. You could consider using anonymous reporting system, training at all levels, kind of right from the top, of course taking complaints seriously, also considering third-party harassment and what that consists of and what it might look like, and continuously monitoring and evaluating any actions that you have taken. So if we break those down a little bit and look at each of those in more detail. So ideally, first and foremost, it is all about that, having that policy and that procedure. So, all companies should have a harassment and bullying policy, which includes sexual harassment. So you want to be including things like who is protected, what the processes are, and how sexual harassment, or any form of harassment for that matter, will be dealt with. And it should also address third-party harassment, which I'll talk about in a bit. But from a process point of view, just a little bit of, I guess, initial advice. If an employee believes that they are being sexually harassed, our initial advice is for that employee to attempt to raise the issue with the person responsible. So to try and clearly explain that the behaviour is not welcome, that perhaps it makes them feel uncomfortable, and ultimately ask them to stop. But of course that, it's a bit of a difficult conversation to have to go through. So if they don't feel able to raise the problem with the individual, then they should be speaking to their manager for that confidential advice and support. Obviously, if matters cannot be resolved informally, or things continue even if they have been raised directly with the person, then any complaints would need to be raised formally under your grievance policy. And then any complaints should be investigated fully and fairly, and as far as possible in a timely and confidential manner. We said about engaging your employees, so this is about making sure that your employees, they're aware of this law, that they know what constitutes sexual harassment. So the slide that Liz mentioned in terms of those examples, the signs and kind of, how to spot it, what to look out for in terms of the people that they're working with, but also managers being able to kind of spot, are things different? Have they got the opportunity to check in and just make sure that, everything is okay? Being clear on how they can report sexual harassment, so making sure that they know that if they do have a suspicion or it is something that they're experiencing themselves, that they know where that they can go with that information. Making sure that they've got access to the relevant policies, so the bullying and harassment or the grievance, whichever policy it is that may apply. But it's also about explaining the consequences of breaching those policies. So policies are there for a reason. It protects the business, but it also protects the employees. And it's just about making sure that, everybody's following those and is compliant. I mentioned training. So from a training perspective, so whilst this isn't required by law, our kind of thinking is that, if you do deliver any training, the sorts of things that you would be wanting to include are what is sexual harassment, what it looks like or even sounds like, what to do if it's witnessed, how the company itself is going to handle those complaints, so who's going to be that person that's going to do that investigation, and how are they going to handle that investigation and make sure that it's done thoroughly and fairly. But then any training that does take place, ideally you want to be having that record so that you've got that evidence there to basically say, look, we trained Lizzie on such and such a day and this is what we trained her on. So having that kind of audit there. From a reporting point of view, when it comes to ultimately employees reporting any sexual harassment, it's just about making sure that you're clear on those reporting channels and making sure that everybody has access to them. I think we automatically assume, everybody's got email and, this and that, but just making sure that everybody does have the same opportunity to be able to report any form of sexual harassment. You could consider the option of anonymous reporting. So companies like Stripe offer that as an option to be able to kind of set up that anonymous reporting system. And it's about keeping records, of all concerns raised as part of that reporting, obviously keeping hold of those confidentially as well. And I mentioned earlier about, identifying circumstances or situations that are at high risk of harassment and putting those plans in place. So this is where the risk assessment comes in, and it is recommended that you complete a risk assessment that will include any historic claims, but, the types of information that you are, you're looking to collate are things like what those allegations were, so a summary of them, where or when it occurred, what those risk factors are, the action, that you took or action that you will take to minimise the risks, and if any action is needed, when that is. Because you've got that duty to assess potential scenarios that may arise and identify the steps that you can take to prevent, that from happening. So obviously if you need any help in terms of carrying out that risk assessment, what that might look like, a template, just get in touch, all of that we can help with. And as part of the preventative duty, you do need to consider third-party harassment. So this is harassment from an external party. So this is, not somebody that is within your business. So, it should be treated just as serious, and it should be part of your process, and there should be, a procedure there for whether or not it is one of your employees that has been subject to third-party harassment, or indeed, one of your employees is sexually harassing one of your third parties. They should have the option to be able to raise that as well. But when we're talking about third parties, obviously it's those people that are external to your company. So it could include your customers, your clients, your service users, your suppliers, your bin men, anyone and everyone that kind of, comes into the company but isn't directly employed by them. And as I said, the steps should be in place for preventing third-party sexual harassment as well. And finally, I mentioned it before, you are required to continuously monitor and evaluate the actions that you are taking, so you need to be analysing any trends in concerns or complaints. So if there does appear to be a bit of a pattern, or the same thing keeps cropping up, then ultimately, there's a bit of a concern there. So, you've got to have the view that, things might need to change, and that's fine, but what is it that needs to change? How is it that we are going to do that? And then potentially going through the cycle again of, training, engaging your team members, and it is that kind of whole continuous improvement cycle that you go through. Because not to scare you, but unfortunately it can get quite costly if employers don't comply. So the European Human Rights Commission can investigate and take enforcement action under the Equality Act 2010. So what they can do is issue what's called an unlawful act notice if an employer is subject to an investigation. And if that happens, employers are required to prepare an action plan to show that they will remedy any continuing breach of the Act and ultimately prevent those future breaches. Because if an employee succeeds in a claim for sexual harassment and is awarded compensation, an employment tribunal must consider whether or not the employer has complied with their preventative duty. Easy for me to say. And where that preventative duty has been breached, the employment tribunal cannot lift the compensation award by up to 25%. So it's quite significant. And the compensation for sexual harassment can actually include compensation for both, past and future, potential future loss of earnings, injury to feelings, and personal injury. So, I couldn't give you a figure in terms of how much it could cost, but it's potentially going to be quite significant if the relevant steps are not taken. And of course, we have to consider the impact that sexual harassment has in the workplace. Sexual harassment can impact the company and also its employees. And if we're looking at it from a company perspective, ultimately it's going to lead to an increase in complaints, that loss of productivity and revenue, potential loss of talent, because if you've got employees who have experienced sexual harassment and they believe that nothing's been done about it or their concerns have not been taken seriously, then potentially they're more likely to leave their job, which obviously then becomes costly for you in terms of, one, any potential risks as to why it is that they've left, but also that whole recruitment drive of bringing somebody in. But actually, it could mean that it's difficult to recruit new talent. If you think of word of mouth, it goes a long way these days, as do reviews on Google and social media, so it can actually be, really damaging to your company's reputation if sexual harassment occurs and indeed is not addressed. And of course, looking at it from an employee perspective, there is that whole emotional distress that they're going to be under in terms of their feelings and the impact that it can have on their mental health. They're potentially going to feel quite intimidated, a bit fearful, embarrassed that they potentially are going to feel like they have allowed this to happen, which isn't always the case. So their self-esteem, their morale, is going to be on the floor, in all honesty. They're going to be struggling to perform. If somebody is being sexually harassed, as Liz said, it's going to make it difficult for them to concentrate, so they are not going to be performing at their best. And ultimately, their behaviour is going to change because they're perhaps going to become a shell of the person that they once were. So yeah, overall, a massive impact in terms of the workplace. So to prevent all of that, as well as what we've already said from kind of a process and policy point of view, you can also look at from an internal and external support and resource point of view. So from an internal perspective, you want to have that senior management or manager, dependent on how big your business is, that leads from the top in terms of the preventative duty, but just sexual harassment in the workplace as a whole, and that they're kind of buying into the steps that the company is going to take. You may also want to consider having a dedicated person that employees can raise their concerns to. So some companies have menopause or data protection champions. So, you could have somebody that volunteers to be the person, that dedicated person that people can go to, so they're going to listen to the concerns and take the necessary steps, whether it's that they investigate it themselves, or they hand it over to a relevant party. But then also from an external point of view, of course, you've got access to us, but there are also, services out there that you can ultimately signpost your employees to. So there's victim support, ACAS, and of course the Samaritans. And I've put EAP on there because some companies do already have this in terms of an employee assistance program, but if not, potentially it is something that you could look to introduce. And generally, an employee assistance program offers a number of different ways in which to help employees. So if they are suffering with their health, then they can advise on that. It could even be that they've got access to counselling, whether it's on the phone or face to face. They are a really good resource to be able to kind of introduce into your company and make sure that support is there for people. And in all honesty, they also help from kind of legal, financial, and whatnot. So they're not just purely for this. So lots to consider, I guess. But just in summary, your responsibilities of as an employer include handling those complaints from your employees in accordance with your policy and your procedures, assisting with those investigations and taking any necessary disciplinary action, obviously ensuring that victims are not adversely affected, and ultimately making sure that that sexual harassment stops and does not reoccur. So, in terms of how we can help, you may have some things in place already, but there may be others that you're keen to explore further. So we can, of course, help with everything that we've talked about today. So whether that's on a project basis, or if you're not a client of ours, obviously, you know, coming on board as a recurring HR client. But some of the things that we can provide you with is the sexual harassment policy. We could even do a grievance policy if you don't have one, the risk assessment template and the advice in terms of filling that out. We could do some training for your managers, so we could do it obviously dependent on location. We could perhaps do it in person or online, you know, facilitate that 2-hour session to kind of cover off, you know, from a management point of view, what it is that they need to be doing. We could provide you with some guidance for your employees in terms of, you know, documents and, you know, a bit of a process there in terms of what it is that they can do. And then we mentioned about the sexual harassment champion. So again, from a training perspective, if you wanted online or in person, you know, we could facilitate that 2-hour session there. But of course, with anything, you know, if you'd like to talk to us more about this, either drop us a message in the chat now, or drop us an email or give us a call and we will be in touch. So as Liz said at the start, we have recorded the webinar. So by the end of the week, we will send you a copy of the slides and a recording of the webinar so that you can obviously see our faces again if you really want to. Have we got any questions in the chat? Does anybody want to pop anything in there? Liz, can you see if we've got anything?
Nothing at the minute.
Nope.
Any questions, anyone? If not, you got 10 minutes. You got 10 minutes back of your day. If not,
yeah.
But, you know, you can always contact us separately if you do have any specific questions. You know, or you know, we're more than welcome. Very open. So yeah, by all means, drop us a line. Okay.
No?
Thanks, Julie. Right. Thank you, everybody. We will close it there. Have
Thanks,
a lovely
guys.
rest of your afternoon. Take care. Bye. 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 Bye.
Bye.
Correct timing.